Chief Justice Mandisa Maya has issued directions or directives on former President Jacob Zuma and the MK party's legal challenge against President Cyril Ramaphosa's decision to place Police Minister Mchunu on special leave or leave of absence. This after Zuma and the MK party filed papers in the Apex Court to challenge the said decision, as well as the decision to appoint Professor Cachalia as acting Minister of Police and the establishment of a Judicial Commission of Inquiry. Now joining us for analysis on the court challenge is legal analyst Mpumelelo, zikalala. Good afternoon, Mpumelelo. Thank you very much, as always, for joining us on the program. So when going through the papers of that applicant, it's apparent that issues they once settled by the court are those being debated currently in the public space around what the Constitution provides for on the placing of a minister on leave of absence, and also the appointment on an acting basis of a non-cabinet member to act for another minister. But before we tackle those prayers, let's start with jurisdiction here. The applicants have brought this matter on an urgent basis in terms of Rule 12, I believe, and they hold the view that the Apex Court is the correct forum to decide on this. Where do you stand?
Well, you're quite correct in the issues that have been identified. So basically there are two. One, do I have direct access? Is it a matter that is exclusively for the Constitutional Court? Maybe the answer would be no, but if you look at the severity of the matter and the type of complex issues which are going to be there, they might be persuaded to agree with what the applicants are actually stating. Secondly, is it a matter in which is going to involve the conduct of the president? The answer is yes, in the manner in which the president is appointed the minister, and what needs to follow from that is also going to be in the spotlight. So the Constitutional Court, at the end of the day, may ultimately have to deal with the matter, and they might choose to say, convince us so that we have direct access on this matter, whether we should be able to accept it or not. The other part of it is agency. Are we dealing with something where there's going to be irreparable harm, a right that needs to be protected, no other alternative remedies, and in a balance of probabilities, you are going to win as the applicants? And the answer to that may be so, because if you look at the manner in which things have been if you look at what our Constitution is saying, it is very strict as to how a person needs to be appointed to be a minister, the manner of appointing a person outside the ministerial powers, and the powers that are there to the president to say, in what instances can you then give someone powers that are supposed to be dealt with by a certain minister, they are given to another person. So it's going to be interesting in the manner in which the court is going to approach this case.
Let's delve deeper then into the orders sought or prayers. Firstly, they want the court to declare irrational and inconsistent with the Constitution the president's decision to place Minister Mchunu on leave of absence. When just reading those papers, my understanding is that they're essentially arguing that leave of absence can be equated to precautionary suspension where an employer-employee relationship exists, but then they go on to highlight that in this instance, an employer-employee relationship does not exist between a minister and the president. You actually serve at the behest of the president. When you place on precautionary suspension, it's because you want to allow a process to dissolve a relationship following the prescripts of the labor law. But in this instance, the president in that relationship would not be subjected to labor laws. He can appoint, dismiss, reshuffle or reassign without necessarily giving any explanation. Where do you stand on just their argument to almost equate it to precautionary suspension where an employee-employer relationship would have existed?
It may be similar, but there are certain prescriptions which are going to apply in both ways. The other way of saying that the person who is the aggrieved party, for example, the minister or any other interested individual, may then take the president to court and say, Mr. President, tell us the reasons of why you are reshuffling this minister and creating an acting one. Remember, all the decisions which are taken by the president has to meet three things. It must be lawful, so there must be legislation or common law that is there that authorizes to do so. Most importantly, it must be rational, meaning what are the factors that you look into that are forcing you or persuading you to look at it in this particular manner? And lastly, it must procedurally fair. If it doesn't mean all these things, then it means that that particular decision is not just and it cannot be accepted to be what it was supposed to be. So this calls upon the president to then say, your decisions are not exclusively yours. You do not have the ultimate power of taking decisions without having to explain them to us as members of the public as why we have taken them. If, for example, the president had answered the letter of demand that was written to the MK party and placed his reasons on that one, maybe we would not find ourselves within the situation that we have now. But because the responding platform has been chosen to be the court of law, then it's the court of law in which we must then attend into. Yes, we may have the power as the president to say, I can appoint, and withdraw and do whatever that I need to do without having to explain. But if called upon to do so, then your decision must be rational and it must be defended. Yes, you have the power as president to say, I'm going to assign and remove certain powers to you as a minister, but there must be some sort of rationality which is required. And if you haven't explained that rationality in an open statement, and you haven't explained that rationality when I've called for one, then unfortunately I have to go to court so that I'm able to explain and understand what is it that has informed you to act in the manner in which you've acted.
Now that you touch on that EFF letter that they wrote to the president asking for greater clarity, I suppose some would say there's no greater clarity than that which comes from the final arbiter in the form of the court, that perhaps this legal challenge will settle the matter, will be all the better for it because the court will decide exactly what are the powers of the president. But then if we go to the second prayer, they're also now seeking for the decision to bring on an acting basis Professor Cachalia to stand in for a full cabinet member. Many had understood that cabinet members stand in for cabinet members. In this regard, where do you stand around the interpretation of the president's powers?
Well, those ones are very clear. If you look at your constitution, it doesn't have any reference to an acting minister. That does not exist. But what does exist is where cabinet members are given assigned powers that are usually occupied by other ministers. It can be twofold. Either the president was thinking in the manner which has been in the public discourse of saying that I'm simply appointing someone on an acting basis, or on a technical compliance basis. Then he says, I'm going to appoint Mr. Cachalia to be a member in the presidency. Remember, as the president, I do not have to appoint a minister and give them full powers at the same time. I can appoint as many ministers as I want to, as long as I'm permitted to do so within the presidency. And then once the president has been appointed within the presidency and cloaked within the clothes of being a minister, then I can assign them to wherever that I want to assign them. Have those two ministers which are going to be Ministry of the Police, for example, but give them certain powers and remove certain powers from others. So I can say, Minister Mchunu, we are only going to have one role in which to do, then the other none or whatever, 99% of the roles are going to be done so by Professor Cachalia. So it is one of those explanations that, for me, if it was explained at an earlier point, we would not have a constitutional court that will have to deal with the matter, but it does assist us because our democracy is a young one, regardless of the years that we have been in. There are going to be a number of things in which you are going to need to navigate, and part of them is assessing the true extent of the powers of the president in terms of the appointment and non-appointment of ministers, and the reasoning behind that we as members of the public can go and seek in terms of holding the president accountable. There's going to be a rational reason why a certain individual is chosen, and certainly that is important for us to know as members of the public.
And then lastly, Mpumelelo, they're also challenging the establishing of a judicial commission of inquiry. Where do you stand on that one?
Well, because it's within the president powers, maybe what they can challenge is the type of references to say, do they meet the type of demands in which the question has been raised? But most importantly, do you even need one? What stems or what has prompted you to start this commission of inquiry? It is an allegation that has been made by a provincial commissioner. Would an inquiry be made up of 3 individuals? Would that have sufficed? If we look at the history, the time and money that has been spent in commissions of inquiries, are you going to get the type of intervention or the type of results that you are looking for? So again, this whole action or the two actions are resting on one point. Show us the rationality in the decision that you have taken, and show us that the decisions that you have taken are going to directly meet and answer the questions that we have, or provide the solutions to the problems that have been raised or placed on your table, Mr. President.
All right. Mpumelelo, as always, thank you very much for your insights. That's legal analyst Mpumelelo zikalala speaking to us there as the president and government is expected to respond to the application brought by former President Jacob Zuma and Umkhonto weSizwe Party.